Welcome to the Pop-Up Law series. The Union Minister Kiren Rijiju expressed the government's intention to thrust the bill in the upcoming Parliament session to repeal 65 more obsolete laws and other provisions while addressing the 23rd Commonwealth Law Conference in Goa, held from 5th to 9th March 2023. With the creation of Ramanujam Committee and representing the Repealing and Amending Bill 2022 last year in December, which intended to repeal more than 60 archaic laws, some being as old as 137 years old, the move to repeal the obsolete laws gained its momentum. What is an obsolete law? This term is applied to those laws which, by a change in condition or subject matter or by long neglect, have lost their efficacy without being repealed. Laws are enacted to regulate society better and make people's life easy. But when the same laws become an obstruction in the developmental work and compliances causing hindrance, therefore resulting in burdening the lives of people, then it becomes the need of the society for such laws to be repealed. The central government has repealed almost 1,486 obsolete and redundant laws in the last 8.5 years. No doubt that when these legislations were introduced, they might have been necessary and relevant, but due to the absence of periodic reviews, with time they have become a burden on the statutory body. In 2019, the Repealing and Amending Bill was introduced. The Union Government proposed repealing 58 outdated laws and making minor amendments to the Income Tax Act of 1961 and Indian Institute Management Act of 2017. Kiren Rijiju piloted the present bill and stressed on the fact that outdated laws are a burden to the system of justice administration, especially when more than 4.98 lakhs cases are pending in various courts of India. Irrespective of having provisions of e-court and unique project phase 3, it is still the need of the hour to repeal the outdated laws in the country. Some of such mind-blowing laws are discussed below, which require to be amended at the earliest. Legal drinking age. It is very interesting to know that the legal age for drinking differs from state to state in India. While the legal age of drinking in Goa, UP, Himachal Pradesh, Sikkim and Pondicherry is 18 years, in Maharashtra it is 25 years. Some states completely prohibit the selling or consumption of alcohol for all ages, like Gujarat. The capital of the country, New Delhi, has an absurd law regarding the delivery of alcoholic beverages at the home, but beer and wine can be delivered from departmental stores to residences. Bizarre qualification to become motor vehicle inspector. As per the Indian Motor Vehicle Act 1914, a person is legally required to have a good and strong teeth in order to become a motor vehicle inspector in Andhra Pradesh. Unlucky lottery. According to the Indian Treasure Trove Act 1878, if any individual finds any amount more than ₹10 on road and fails to report about the same to the local authorities, such an individual shall be prosecuted. Flying kites is illegal. The Indian Aircraft Act 1934 states that an individual needs to get a permit to fly an aircraft. Strangely, kite is also considered as an aircraft, and hence an individual is required to attain a permit to fly a kite in India. The Indian Sarai Act 1887. Under this law, even a 5-star hotel cannot deny anyone either from drinking water or using their restroom, even if such person is not lodging there. Penalty on having a third child. As per the Law Reform Commission of Kerala, a penalty of ₹10,000 is imposed on any couple who has more than 2 children. Further, the Commission also removed facilities like free education, scholarship, and healthcare for the child and his or her parents. Let's understand the repealing power of the Parliament. Under Article 245 of the Constitution, empowers the Parliament to make laws for the whole or any part of the India. The state legislatures have the power to make laws for the states, and the same provision empowers and enables Parliament to repeal a law. The Union Minister opined that some legislations need not be repealed since they have a sunset clause, meaning they cease to exist after reaching a particular date. For instance, Terrorist and Disruptive Activities Prevention Act 1987, also known as TADA, was allowed to lapse in 1995. But since most of the laws do not have a sunset clause, it becomes necessary for the Parliament to enact another legislation or pass an ordinance to repeal the law. If such an ordinance lapses due to non-approval by the Parliament for 6 months, the repealed law can return to life. Generally, the ordinances passed by the government has to be passed by both the houses before receiving the President's assent and coming into force. Lastly, the truth remains that unmaking the existing law is more intimidating and unsettling than making new laws. Hence, the Parliament cannot do it alone without the active participation of the state assemblies and a permanent commission in place for a periodic review of the existing laws. Kindly let us know your views on it, and to know more, please click on the link below.